regulations in the athletics context.
I mean, I think a lot of people would say, you know, if you look at the ranks of chess grandmasters, there are not a whole lot of women there. And, you know, what does that mean? Well,
I think, right.
you know, I think that there's a sort of intuitive, I think there are a lot of chess grandmasters who would tell you that women just like, for whatever reason, they're, you know, they're not as good as this.
I think chess is an interestingly closer question. I've come to understand just recently, in fact, that there are sex distinctions
well,
in the elite.
You're fighting the hypothetical, and I guess the question really is, okay, Title IX says you can't discriminate on the basis of sex.
Yeah, sure.
I understand what that means. I think I do, right? Can't treat men and women differently. Okay, all right, fine. But you're saying, but it matters whether they're similarly situated, and your friends in the government like that line too. Well, there's, you know, I got a lot of evidence that girls perform a lot better in high school than boys. Okay, there's a lot of scientific evidence, or whatever, or they just posit that, all right? Well, so I'm going to have a special remedial program for boys, and the women can't come. And because they're not similarly situated. Why on earth would Title IX care about that? It says you can't discriminate on the basis of sex in a program or activity of your educational institution.
So I think
why put that gloss on it?
And Your Honor, I want to be clear. I think the task for the court today is somewhat easier in part because of the express regulations that they have actually not challenged and that do expressly contemplate exactly what West Virginia has done. So I think your hypothetical, yes, of course, is there, but I think the reality is that Congress and the agency have together kind of addressed this specific question in a way that makes this court's task much easier. But I think the problem maybe with
another answer, we don't need to rely on this similarly situated argument? Is that what you're trying to tell me, counsel?
I think you could also take that approach, yes, Your Honor. And I think the reality is that that hypothetical addresses a situation that's much closer to the sort of exclusion and the specific context that gave rise to Title IX in the first place. And so I think that the court would be much more legitimately concerned that that would detect the very problem that Congress is trying to head off in passing Title IX in the first place. But I think that really kind of puts the lie to the position that West Virginia is somehow discriminating because it's advancing the very same purpose that Congress itself was trying to advance in enacting Title IX in the first place. I mean, that's why West Virginia somewhat deliberately made its law mirror the exact same language from the express regulations themselves.
I'm afraid I've got one more question. Oh, I'm sorry. Please go ahead. No, you're.
I can do both.
No, you can't do both. That's not fair. That's not fair. I mean, even by our standards. You make the argument that on the basis of means solely because of, solely. We have long said that because of means but for, not solely because of. The Rehab Act speaks of solely because of. It seems to me an awful big stretch, counsel, to say that on the basis of imports anything other than but for causation. And, you know, Comcast is against you there. And I just wonder why you put your eggs in that basket.
So 3 answers, Your Honor.
And by the way, isn't the distinction here solely because of sex anyway?
Well, let me take each of those in turn, or I'll try. I don't think that the case turns on the court accepting the idea that it's solely on the basis of sex. So I think you could stop.
That's a sufficient answer right there.
Fair enough.
Thank you. Your turn.
Thank you.
Can you explain the relevance and significance of the Javitz Amendment to distinguishing sports from all these other hypotheticals?
So I think the relevance and significance is Your Honors are faced with a unique set of regulations in that Congress was directly and intimately involved in both the instigation of the regulation in 1974 and then sort of—
And in that law referred to the nature of particular sports, right?
It did. So what they said was, we want you, the agency, Hugh, to go ahead and implement Title IX writ large, and it called out one specific problem that I think arose on the floor about whether Title IX applies to intercollegiate athletics, in particular intercollegiate athletics. And I would say—
And that's been extended to high school
right.
by the regulations. But,
exactly.
But ruling for you on sports does not open the door, in my view, given the Javitz Amendment, to the chess club necessarily. That could be separately analyzed, but it doesn't follow from a law that says sports.
That's exactly right, and that's exactly why we were trying to make your job easier in the sense that we took the language expressly from the regulations and mapped it over under our own statute. So there's really no debate. If it's outside the context of Title IX, it's outside the context of our statute. So at that point, the court's analysis is done. But I think when you have a regulatory scheme where Congress was specifically involved, in fact, undertook a review, then that's exactly the sort of regulation that even in a post-Loper Bright world continues to have importance because it's longstanding, continuous, contemporaneously issued, all those sorts of check boxes that this court under a Skidmore framework continues to place substantial weight on. So I think that makes the court's task relatively straightforward.
And what about Bostock?
No.
You want to deal with Bostock?
I think, so I guess it depends on the way in which you mean it. Does it deal in Bostock?
Well, if an employer said we're going to fire all the transgender women,
Right.
that'd be a violation. If a school says we're not going to allow the transgender women to play sports, you say that's not a violation. Both statutes use the term sex. Can you explain?
I think the reason why is, well, to be clear, our statute is very different from a specific choice to say a transgender person shall not participate because of their transgender status. And I think that really is what makes the difference between this case and Bostock, is Bostock is attacking status-based discrimination, and West Virginia would, I think, be in a much different position if we had just said transgender persons shall not compete. But that's not what West Virginia.
What if it said transgender women and girls shall not compete in women's and girls' sports?
I think, again, that's a much closer question. I think if we're talking about engaging with the actual status.
You think you could lose under Title IX with a statute that said that?
I think Bostock, I think, is, now I understand Your Honor's question. I think Bostock raises an interesting question as to whether that reference to transgender status would in turn implicate the sex status that Title IX is meant to address. But ultimately, I think the court doesn't need to address that because you can stop at the first step, right? You don't have an actual transgender exclusion that would give rise to that kind of linkage of analysis.